In this video, we'll discuss about Wassiyyat or wills under Islamic law. So, the very meaning of Wassiyyat as provided in Hedaya, the ancient oldest source of Islamic law, a Muslim has the testamentary power of disposing of his property, but this testamentary power is limited to the disposal of only one third of his property. The Muslim law of wills is a compromise between two opposite tendencies. One, when the Prophet has laid down clearly specific and detailed rules for the distribution of the property of a Muslim after his death among his heirs, it is natural to consider to be a moral duty of every Muslim to make arrangement for the distribution of his property within specified limit of one third after his death. This seems to be the reason why the word Wassiyyat has two meanings. It means a will and it also signifies a moral obligation. So, as the very word Wassiyyat also means a specific legacy or the capacity of the executor. The will of Muslim is governed by Muslim law as the very provisions of state testamentary succession as it was expressed by Amir Ali also Fyzee in his work Islamic Law of Wills and regarding the very conditions of Muslim law of wills or Wassiyyat. Under that, we would like to discuss the very capacity to make a will. So, regarding the capacity to make a will or a Wassiyyat, the views of Tyabji, Professor Baillie, and also Amir Ali's opinions we would like to discuss. So, every Muslim who is sound of mind and of the age of majority has the capacity to make a will, as has been seen earlier in this work, with the exception of marriage, dower, and divorce. The age of majority of Muslim is regulated by the Indian Majority Act, under which the age of majority is the completion of 18 years in ordinary cases and completion of 25 years in cases where the guardian of a minor is appointed under the Guardian and Wards Act, as it was upheld by Tyabji in his Muslim law. So also, as Professor Baillie held Muslim lawgivers laid down that a will of a minor can be ratified by him on attaining majority But the will of a person of unsound mind cannot be ratified on his regaining sanity. And as it was expressed by Professor Bailey under the Shia law, a will made by a person who has taken poison or has wounded himself with a view to committing suicide is invalid. So also a will made by a person who subsequently commits suicide is valid, as it was held in the leading case Mazhar versus Bodha in 1898 by the Allahabad High Court. And the second conditions of making a valid will, that is regarding the formalities of a will. And as per the formalities of the will, Muslim law requires no specific formalities for the execution of a will. A will may be oral or in writing. When the will is in writing, no specific form is laid down. It may not be signed by the tester or attested by his witnesses, as it was expressed in the Holy Quran. So also it was offered in Abdul versus Murtaza in 1991 by the Patna High Court. So the very formalities of a will, and regarding that, when a will is oral, no form of declaration is necessary. Obviously, the burden of establishing an oral will is very heavy. On an oral will must be proved with utmost precision and with every circumstances of time and place. So, in Fatwai Almgiri, it was expressed by Tyabji that a Sikh man makes a bequest and being unable to speak from weaknesses gives a nod with his head, and it is known that he comprehends what he is about. If his meaning be understood, and if he dies without regaining power of speech, the bequest is lawful, as it was explained by Professor Tyabji by quoting Fatwai Almgiri. And now we'll discuss regarding the very third valid condition, that is regarding the subject matter of will, and regarding that any type of property, immovable or movable, corporeal or incorporeal, which is capable of being transferred, may form the subject matter of a bequest. It is not necessary that the subject matter of the will should be in existence. When the will is made, it is sufficient if it is in existence at the time of the tester's death, as it was expressed by Professor Bailey in his volume on Digest of Islamic Law. So also Professor Tyabji expressed that a right to occupy a house during a future period of time or to take the rents or future produced for the lifetime of the legatee may validly constitute the subject matter of will. So, as has been said earlier, the testamentary power of a Muslim is limited to the role bequeathable one thought. So, this was also upheld by the leading case Abdul and Murtaza in 1991 by the Patna High Court. So, the very concept regarding bequeathable one third means a third of the estate of a testator as it is left after the payment of his funeral expenses, debts, and other charges. The law in this respect may be stated that all schools of Muslim law, except the Idana Asari school, hold that the bequest of more than the bequeathable one third is invalid unless consented to by the heirs after the death of the testator, as it was also held in the leading case Abdul versus Murtaza in 1991 by the Patna High Court. So, consent can be informed from the very conduct of the legal heirs, and as it was also held in the same leading case Abdul versus Murtaza by the Patna High Court in 1991, and regarding that one we found according to the Itnasari school the consent of the heirs to validate a bequest of more than one third may be given even during the lifetime of the testator, so does not need ratification after the death of the testator. And as regarding the conditions, if a testator has no legal heirs, he may dispose of his entire property by a will. The right of the estate or the state to take the property does not prevent the heirless testator from bequeathing his entire property. So a request or bequest of more than one third may be validated by the consent of the heirs. The rationale behind this rule is that the limitation on the testator's power of disposition is solely for the benefit of the heirs, and if they want to forego the benefit, they are free to do so. The consent of heirs may be express or implied. Where a testator died leaving behind only a wife or husband as the sole legal heir and no blood relations, then if the testator is a male, he can bequeath 5/6 of his estate, and if the testator is a female, she can bequeath 2/3 of the estates, as it was held